be distributed. And so Anne was not on notice that she was facing any kind of a non-divorce cause of action, because Farrell was asking that the marital property be distributed. Anne's whole tactic at trial was to demonstrate that this home was not marital property, and indeed she succeeded on that. But no, I don't think that she had the kind of notice that due process would require to construe the counterclaim as a claim for unjust enrichment.
If we have the precedent sitting out there, Lindsay versus Lindsay, that tells us that in extraordinary circumstances, a trial court can, at least theoretically, award premarital assets as part of the marital distribution in divorce. You think I'm misstating what Lindsay said?
There is a doctrine allowing in extraordinary situations for that to happen.
Now we agree, so here comes my actual question. If a trial court in determining a divorce where one has pled that they want to divide marital assets, seeks to use that doctrine of extraordinary circumstances and reach outside what traditionally would be considered marital assets to premarital assets as part of the marital distribution, do they have to state that as a separate claim?
I would think that the trial court would absolutely have to explain.
That's not my question. This is a question of pleading.
Of pleading.
Because your appeal right now,
Yes.
if I look at the 5 things that you've listed, are going to amendments of pleadings and what you have to plead. And I'm trying to cabin that for a moment and simply ask the question that if you are proceeding under the extraordinary circumstances theory, whether, I understand, it's a separate question of the trial court has to have adequate findings and actually make a finding in extraordinary circumstances. Setting that aside for a moment, does it have to be separately pled? And if so, would your statute of limitations argument even apply to such a circumstance?
Well, I think that Anne has to have notice of what she's facing and what kind of evidence she needs to present. So I don't know that we have to invoke a strict rule of pleading in which Farrell had to use certain magic words. But I do think that she has to have notice. In terms of the statute of limitations, I would not think that the statute of limitations would apply to the extraordinary situation doctrine. I would note that the first time this case was before the court stated that doctrine does not apply here.
Right.
And I also note that on remand, the district court did not rely upon or mention the doctrine. So the district court relies solely on unjust enrichment, and for that reason, that's been the focus of our argument and our appeal.
And do you lay that at our feet? It appeared that in Oldroyd, the first time around, I repurposed Oldroyd 1, I guess, this court suggested that some sort of theory had to be identified by the court, and this court expressly mentioned unjust enrichment. Is that your feeling? Among others. But
Right.
do you think that's why the court may be
Focused
on that?
I don't know. This court said it could have been quasi-contract, it could have been promissory estoppel,
Or some other
it could have
theory.
been unjust enrichment or something else. I think that, I don't presume to speak for the court. My feeling is the court just did not know. The court wasn't sure what the basis for the district court's judgment was, and so the court sent it back and said, what was the basis? And now the district court said the basis was unjust enrichment, and no, I don't put that at the feet of this court. That's what the district court said.
Very good.
Back to my point that the theory was never pleaded, the district court viewed it as unpleaded. The district court remarked that the court has the authority to rely upon legal theories not pled. This court viewed the theory as unpleaded when it said, nor does our review of the proceeding below indicate that Farrell identified to the court a particular theory under which he was entitled to a premarital interest. Furthermore, as I've already mentioned, if the court will look at the counterclaim, the court will note that it is only for divorce, and it only asks for division of marital assets, which this was not. And finally, Farrell stated in his trial brief, and again at trial, that the unjust enrichment claim was barred by the statute of limitations. So he obviously wasn't pleading it. He said that it was barred by the statute. So because the claim, the theory upon which the district court relied, because it was not pleaded, the district court would have had to make a finding under Rule 15 that the issue was tried by the consent of the parties. And it certainly was not tried by the consent of the parties here. As we've noted in our brief, the words unjust enrichment appear only twice in a fairly lengthy trial transcript. The first time is when Farrell's lawyer says, we can't rely on it because we're barred by the statute of limitations. And the second is when he's questioning Anne, and he says, well, if there hadn't been a divorce, wouldn't Farrell have been able to sue you for unjust enrichment? Mr. McConkie objected. The court sustained that objection. That's the only mention of unjust enrichment at trial.
Without using that language, do you think that it's fair to say that his trial theory was that he had put so much effort into making the house what it was, that regardless of her putting in the money up front to buy the lot and to buy the materials, that it basically just isn't fair that he doesn't come away with more by virtue of all of his labor?
I think that is his argument. And I do want to be sure that the court remembers that Anne has agreed that he may share half of the appreciation of the home. And there are a lot of pictures attached to his brief. All of that work was done after the parties moved in together, and he's been fully compensated for that. All that she is asking, and I think she was overly generous, and I hope she won't be punished for it, but all she's asking is that before the house is divided, that she receive her $350,000 back, that she get a credit for that, the actual money that she put into the home. Finally, even if the issue had been pleaded, Your Honors, the elements are simply not established. First of all, Farrell did not receive something for nothing, and Farrell did receive something. He got $18,000. He got a place to live, and he used the home as the shop for his business both before and after the divorce. Second, he didn't prove damages as required by the case law. The Utah Supreme Court has said that in services rendered cases, the proper measure of damages is the reasonable value of the services. And Farrell did not show what it would have cost to hire a different subcontractor, and Anne didn't know that she needed to put on that kind of evidence. She didn't know that she needed to present evidence as to what it would have cost her to hire someone else who provided those services.
Wasn't there I think it was Anne's expert who testified that it would have cost approximately $800,000 to build this house in 1997?
We were trying to show the value of the home so that it could be divided.
But that wasn't the value of the general contract services?
No, that in my mind, the whole point there was, what is the value of this home to be divided? And so we took the $850, we subtracted the mortgage we want to subtract the $350 that Anne put in of her own separate funds, and then divide the house. With the court's permission, I'd like to reserve the remainder of my time for rebuttal.
Absolutely. Thank you, Mr. Wright.
Please support Brian Arnold on behalf of Mr. Oldroyd here today on this appeal, coming back a second time. I'd like to start with the very thing that he ended with, and that's the experts in this case, and that they didn't have notice. I think it goes to all those issues. The experts actually did testify to the value of Mr. Oldroyd's contributions to the house. In fact, if you go down the exhibits that were admitted into evidence, they actually put in labor, expertise, and those items. If they were not trying to prove what Mr. Oldroyd gave or contributed to this marital home, they would have never gotten an expert to do so. The expert could have simply appraised the value with the 1997 value, which they did not.
But the court in its supplemental findings specifically says that the value of respondent's contribution to the building of the Morgan home cannot be precisely determined in dollars and cents. And you haven't challenged that. I mean, it's a kind of a non-finding, but you haven't challenged that there was actually evidence that was submitted at trial to contradict that finding, have you?
Well, no, because of the further finding by the court in paragraph 22, it says before the marriage, both petitioner and respondent contributed equivalent value to the construction of the home. So while they did not find it in dollars and cents based on the expertise and stuff that were testified, they found that they contributed equal value to the home. He didn't come up with, you're right, the judge didn't come up with the dollars and cents, but that's why he went into that in paragraph 22, but also further goes into saying that neither of them could have had this home without each other. Without Mr. Oldroyd's contributions and skill, labor, and also without Ann's money, they could have never had this house. And that's why their argument at trial was he had been paid for his services, because they wanted to get away from the value of that, because they knew that was the issue coming to trial. And that's why they tried to say that he had been paid for his contributions to the home, which the court did not find credible and found that that was a gift to meet his financial obligations while he built the home.
One of the concerns I have here now is the precedent that this case is going to set moving forward. Because it appears to me, at least, that it has potential to add a certain element into our domestic case law here in Utah that could be quite troubling. Because if the argument is that when a spouse confers upon another spouse some sort of benefit that they can then attempt to put a value on, that can inure to an award of attaching to premarital assets, I'm wondering where we draw the line. For example, I can think of a couple of examples. Let's say that the spouses are married and one of them has a parent that's gravely ill. They move them into the house, take care of them for 10 years, get a divorce shortly after or during the divorce, mom dies, and turns out in her will she said, because my son-in-law and my daughter took such good care of me, I'm giving them a larger portion of the estate. And you get an inheritance. Typically, historically, inheritances have not come within the realm of marital property. But would that benefit conferred during that, now all of a sudden, because of the labors of a now ex-spouse having occurred, would unjust enrichment attach there?
I think, if I understood your hypothetical correctly, Your Honor, that you stated that the grandmother or whoever stated that my son-in-law and my daughter-in-law, so I'm giving them a bigger...
Well, no. I meant to say that I'm giving my daughter. So she has several children, but because of the efforts of an ex-spouse, she determines that she's going to give the daughter more money. I'm trying to identify things that are typically not in the marital estate. A similar one would be there's an accident during the marriage, maybe even arguably because of the injury, it contributes to the dissolution of the marriage, but ultimately they get divorced. And 2 months after the divorce, the injured spouse enters into a settlement and gets $1 million for their injuries. Can the other spouse now claim a portion of the personal injury settlement, which typically is not a marital asset?
Right. So, if I understand that, yes. I mean, they can, on certain parts of that settlement, the pain and suffering, no, the court has found, I think in previous cases, that is separate property unless it is commingled.
Right. But does this open the door to re-examining that? Under a theory of unjust enrichment, that she shouldn't be able to retain the benefit that was conferred?
No, I don't think so in that situation, because she's not giving a benefit if the spouse settled afterwards. She didn't give a benefit to him that could be ascertained to him if it's an award for a personal injury that he suffered. I see in general what you're asking, and I think when there's a benefit given to somebody premarital to an extent that you would have an interest in it under other theories of law, I think absolutely it can, under this case, if it was decided the way we're asking it, it would open the door to that.
Why, and here's my next question, why should we create this kind of pocket of equity to reach outside what is typically the marital estate when we already have Lindsay versus Lindsay on the books? When I look back over this case, I'm the newcomer here. I wasn't around on Oldroyd 1. But when I read Lindsay and look at this, why couldn't this case have been decided under extraordinary circumstances? Why couldn't the district court have said, given the extent to which Mr. Oldroyd contributed to the destruction of this home, this is an extraordinary circumstance, and so although it is a premarital asset, it should be part of the marital distribution. What, are you saying that couldn't have happened under Lindsay?
No, I'm not saying it couldn't happen. I think in a way the court did that, but they didn't explicitly say extraordinary circumstances. I think if we go through their findings, because of the extraordinary circumstances, because of what was contributed, because of the expertise, because of what the experts testified, this is a circumstance under which, because of the circumstances, unjust enrichment fits within that to provide, he provided her with a benefit that he needs to be compensated.
Of course, in Oldroyd 1, we noted that wasn't stated, that wasn't found.
Right.
And I think arguably now, we're sitting here under a mandate rule that I don't think in my head, I actually get to extraordinary circumstances past the mandate rule here. So if that was an available theory that now has basically been cut out by the mandate rule, why should we, see what I'm asking?
Yeah, why should we
create something new
Right.
that adds precedential complication to the world? You see my question?
I do see, I think based on the facts of this case, I think I understand you correctly. Why should we open the door to maybe another theory that's like extraordinary circumstances?
Exactly.
Okay. So if I understand, because maybe I'm, the way I understand Lindsay is because of those facts, it opened up that. And I don't think that the court specifically has to say extraordinary circumstances in making their decision, but I understand what you're saying, that it was one of the things allowed to the district court to do. But I think the district court found, because of these circumstances, unjust enrichment fit and didn't go that route. And I don't know why they didn't go that route. I know there was post-briefing, right, when we went back, and oral argument on that issue.
Here's what these two theories part roads, and this is where it becomes both cumbersome and troublesome. Under Lindsay, when you find extraordinary circumstances, then you basically are concluding as a legal theory that premarital assets, because of extraordinary circumstances, that should be considered as marital assets. The difference here is that we're determining that because of unjust enrichment, we're going to give Mr. Oldroyd a premarital interest, right?
I think the other way around, I think he decided he had a premarital interest, and it would be, she would be unjustly enriched if she was to receive his premarital interest.
Right, but the premarital interest is based on a quasi-contract theory, right? That he did work for which he should have been compensated. She knew that he should have been compensated for it, so that's hanging out there, right?
Yeah, yes, correct.
Okay. So, but what the court found was a premarital interest
Yes, for both parties.
for both parties, right?
Correct.
Right.
And then based on unjust enrichment. Yes.
So do you see how those differ?
Yes, I do see how those differ. Yes, and so you're, if I understand you correctly, Your Honor.
Yeah.
Sure. You're saying by finding a premarital interest for Mr. Oldroyd, you're saying he should have found extraordinary circumstances.
I'm just saying that would be, to me, the more stable theory to have in our case law, because that then kind of endows this with kind of stays within the box, so to speak, of domestic law. If we consider it, because of extraordinary circumstances, as marital property, nobody questions that a trial court has the ability to distribute marital property. On the other hand, if we're opening a door in domestic cases for associations, efforts, or whatever happened premaritally to endow people with premarital interests in other people's property, then it seems like we're opening a can of worms.
Well, I think extraordinary circumstances already under Lindsay opens that can of worms. I think any time, any case that could always be argued, now whether that be successful or not is another question, but the can of worms has already been opened by that case. I think that this doesn't really, it's quasi the same thing, it just doesn't say extraordinary circumstances. So I don't think it's opening anything new that's not already available.
But isn't the difference between Lindsay and this case the contribution to the asset that needed to be divided at the end of the day? In Lindsay, the contribution came during the marriage. Here, any contribution by Mr. Oldroyd came before the marriage. And I wonder if Judge Mortensen is correct in that it's kind of creating a new legal theory about dividing property trying to use it domestic principles, when really what we have is a quasi-contractual sort of cause of action that's being asked for. Am I making sense?
Yeah, sure. I mean, I think the reason why the court did it this way is because of the finding. So if you find each party has a premarital interest, and they technically both contribute that premarital interest into the marriage and receive the benefit from it, I think then if we don't decide it this way, then we're still opening that door up, then we have to go back and decide on the premarital interest and then value it on what his appreciation was also. And doing it this way, finding that they both contributed a premarital interest that's equal and towards a common goal, which if you go through the facts the court found, that's what they're doing, they're building this house together for the marriage and both contribute equally to it. Then that's why we can divide it equally as property, because they both contribute equally. If not, then we've got to go back, and we're still opening the door in divorce cases to a premarital interest and deciding how that has equated for Mr. Oldroyd and how it's appreciated. And that's why there were experts in the case, is to even decide that. Because in our counter complaints, that completely continued to be ignored by opposing counsel, we did plead that he contributed and needed the value of half the home because his contribution of his expertise, trade work, and things that Mr. Oldroyd did contributed to that.
And so maybe your response to Judge Mortensen's question is what you are asking us to do is if we don't go your way, you're saying that people who are involved in relationships before they get married, and they do stuff together, they create things for their marriage in anticipation of marriage. All those people need to really have some written agreement about how it's going to be divided in the event that there's a divorce, right? I mean, you're telling us that we need to be careful about quantifying pre-marital relationships so that expectations must be clear, otherwise you're screwed.
Because otherwise,
Sorry.
no one,
That was a little bit.
yeah, because no one then can decide. I mean, you're almost in a way eliminating premarital interest by either party at that point, the argument at all. And so if you don't have that argument, then you can't work it out.
Well, she clearly has a premarital interest. She used her money.
She used her money for, and that's why he could have premarital interest also by using skill that the next was accessible to. But my time is up. Thank you.
the issue before the court is a non-divorce cause of action. I think that's entirely appropriate, and I think that that's how the court should conduct its analysis here. And I think that the case law is adequate to decide whether or not the elements of unjust enrichment were met. In this case, I do not believe that they were. I have concern generally if the court handles this case using divorce principles, because the extraordinary situation doctrine indeed applies when post-marriage the parties have done things. We look at contributions after the marriage. That's the case, as the court pointed out in Lindsay. It's also the case in Elman versus Elman, 2002 Utah App 83. That's another case in which the court applies the extraordinary situation doctrine, but it does it based upon post-marriage activities of the parties. And marriage matters. It has an impact. It has a legal impact. And we can't, I think it would be a nightmare to go back and say, well, you don't really have to plead non-divorce causes of action if you have them. You just have to ask for a divorce. And then suddenly, parties are faced with perhaps breach of contract, perhaps promissory estoppel, all of those kinds of issues. I think that Farrell could have adequately protected himself in these cases by alleging non-divorce causes of actions if he had them, or in the alternative, obtaining a prenuptial agreement. That would have been another way that the parties could have worked this out. But this...
And I guess that was the question, right? Are we, if we decide in favor of Mr. Oldroyd, are we sort of mandating, if we decide against Mr. Oldroyd, are we mandating couples should have, are we basically saying that couples should always have a premarital agreement?
No, I don't. By ruling in his favor, I don't think the court is saying that at all. I mean, I think the case may be an important lesson to the parties down the road about the wisdom of that. I think what we're saying is, if you're relying on non-divorce causes of action, you need to plead them, and you need to prove them. I don't think that that's revolutionary. I don't think that that's unfair or problematic in any way. And if you're relying on pre-marriage issues, then you need to deal with the law as it would apply to any other parties. What if the day before the marriage, Anne had decided to back out? And the parties had never been married. This would have been her home. He might have been able to make some claims against her, which he did not do, and still has not done. And so I think the case needs to be decided based on unjust enrichment. And without, if the court has no further questions, I'll relinquish my remaining 3 seconds. Thank you.
Thank you, counsel, for your argument today. We appreciate it. Very helpful. We will take this matter under advisement and render a written decision as soon as we can. Hopefully quickly, because it's been a while.